Welcome to Startups in the Law. I believe this is our sixth Startups in the Law event that we've held. We usually hold this event the first Tuesday of every single month. Unfortunately, because Austin Startup Week was at the beginning of this month, and because I was traveling last week, I had to reschedule this. But for those who are here, thank you for coming. I really appreciate it. To give you an idea, so to give you some background on this, Matt Jones is the other partner of my law firm. Our law firm basically handles four major categories, serves four major categories of people or companies, entrepreneurs, startups, really rapidly growing companies, as well as investors. We do the buy side, we do the sell side, we do the startup side. We do it all. And I mean, we like to say that we help people get through the life cycle of an early stage startup, and usually get them up to Series A, Series B, Series C before they've outgrown us. If you have any questions for us for this live stream, feel free to email Matt Jones at mjones@fergelaw.com or email me at kyle@joneskertz.com. I usually try to respond to questions if you have any. Also, throughout the program, please feel free to ask any questions directly in the chat or the comments. I believe Trip Gwynn is going to be here, and he's going to be sort of stopping me every now and then as I proceed through the slides in order to jump into some Q&A. So feel free to ask those questions. I know you're going to have some. Aside from that, though, I mean, there is a mission for why we do this. So the idea here is step one, better education, which leads to a better foundation, which leads to more successful startups. Many people have probably heard the statistic that says 9 out of 10 new businesses fail. Well, the reason for that oftentimes comes down to, a lack of education for the founding members. Inexperience on their part. It might have been the first time they ever started one. It is often the case that first-time entrepreneurs fail. But that said, from what they learn, a lot of times that reduces the failure rate for their second business. This is the overall goal. To give you an idea, and when we say foundation, we're talking legal foundation. A lot of this is, it's a legal foundation plus a business foundation, which, in our world are practically the same thing. So, in many cases, we use contracts to facilitate deals. We make sure that we're protecting people. We make sure that we are actually preserving rights for people in the future. As far as laying a legal foundation, we try to get in at the very ground floor with some of the people we work with, as well as some of the companies we work with, to make sure that they're starting their business from the ground up the way they should be, and a way in which that they could do potentially even a handoff in the case that they get acquired. And that's the goal that we have in mind is, we create those processes from the beginning, help you learn about the foundation from the very beginning so that you become a more successful entrepreneur and a more successful business. Generally speaking, here are the topics we're going to cover today. We're going to go through some legal updates. We're going to go through some startup formation and structuring, venture capital deals, essential startup contracts, and employment law for startups. We may not get through all of this today, though I'm going to try to work through it as quickly as we possibly can while still allowing for some time for Q&A. To give you an idea of that was from a previous slide, but there are some CARES Act updates. The CARES Act has actually been somewhat simplified. So I believe the rule now is if you have taken a PPP loan of less than $50,000, there is now an easy form that you can file. I would recommend for anybody that did that you actually go on and you take that you take the easy form and fill it out. And by the way, you might ask your bank, hey, I only took $45,000 in loans, $40,000 in loans. Do you have the form that I need to file? Ask them about it. That's probably your best bet. I mean, you could probably pull it down yourself, but usually, I mean, I believe the government has left it up to the banks to really take care of the PPP stuff. Also, if you have an accountant, your accountant is probably another good person to ask about this sort of thing. And so try to look at those professionals and those people when it comes to taking care of that. Aside from that, you might have heard that that Ruth Bader Ginsburg recently passed away. And I mean, I just want to say for a second, you know, while a lot of people might view politics, might view her politics in a certain way, or might view what she stood for as political in nature, the reality is Ruth Bader Ginsburg was a bit of an icon. I mean, from a legal standpoint, she was really the first true celebrity of the Supreme Court of the United States. She was an anomaly in that way. I mean, some people might say the same of people like Scalia, but Scalia was not nearly as celebrated as Ruth Bader Ginsburg was. And so, I mean, the timing of the new Supreme Court appointment is also pretty pretty critical here, because we're coming up on a major election. But I just wanted to take a moment to tell you guys, I mean, regardless of what her politics were, I mean, we have to acknowledge that, yes, I mean, she was, I mean, people on both sides of the aisle considered her vitally important to our legal process and the way we run our democratic society. So aside from that, I will tell you, I mean, as far as the election goes, please go out and make sure to vote. Extremely important for you to do that. I mean, especially for local elections. It's not just a presidential election. Make sure you're doing your research. Make sure you figure out who you want to vote for at the municipal level, at the county level, et cetera, et cetera. Those are especially important as well, especially wherever you live. So, I mean, to give you a broader idea, today we're going to talk about business formation and structuring for startups. This is something that we have discussed at length in the past, and I believe I discussed this back in April or May to start. But I wanted to approach it again because it's been about 6 months since we last talked about it. And I mean, while yes, some of this might be recycling old material, the reality is it would be new material for quite a lot of people who are attending this presentation. And so I want to go through LLCs. I want to go through corporations. I want to go through different structures and the pros and cons of the different types of entities, so that you can understand, okay, what about this really makes sense for me starting my business. And I'll use some real world examples to discuss how to do it properly, how we've seen it not done properly, and what to do about it if you didn't necessarily start the right entity for you or have to convert into a different one. So without further ado, so limited liability companies, by and large, are going to be the largest, or at least from a volume standpoint, started every single year, the major type of entity that most people will use. The LLC is, I mean, in many ways, most appropriate for people who are starting pretty closely held small businesses. In many cases, LLCs are usually not going to need much more than a cash infusion from the people who are starting the LLCs. So, I mean, if you're looking at, okay, I'm going to need to raise $500,000 for my business, you might look at starting a corporation instead, and we'll get to that here in a little bit. But I mean, if you're not self-funding, I mean, or if you are self-funding, an LLC is going to be pretty appropriate for you, at least for the time being. And so some pros, some cons. I mean, LLCs are super easy to form, whether it's a single member, whether it's a multi-member. These things are pretty standard. I mean, you get an operating agreement, or in the state of Texas, what we call a company agreement, which is the same thing, pretty much. I mean, you're going to have a really flexibility and simplicity of operation. And what we mean by that is you don't have to go through a board of directors to sit here and make a major material decision about what you're doing with your business. we are not going to sit here and bog it down with bureaucratic measures unless you have a board that you are relying on for advice. And usually the board is created when you do want that advice, like and you want to screen certain decisions to protect current lines of business, current income streams, things like that. Super simple management structures. You're either going to have managing members or you're going to have managers. And usually the managers are going to be members as well. Though I'll tell you more often than not, what we start for people is going to be a manager managed type of limited liability company, which allows for maximum flexibility. I mean, really, we're for the most part, like when we set it up that way, whether it's a single member or multi-member, it allows you the ability to designate a manager of your company who would have legal authority over certain things like running the day-to-day operations, cutting checks, moving money in the bank accounts, taking loans, things like that. And so you can make somebody a manager that is not also a member. And that is one of the key differences between a member managed and a manager managed business. I mean, you can effectively have that employee set up so that they have management control. And then, usually what we're doing is we're making the members who are not the managers of that company just sort of passive. So and in that case, I said previously, like, let's say you're taking money. Well, in some cases, LLCs do take money. And sometimes we put those people in the operating agreement. We make them members. We give them a percentage of the company in exchange for their capital contribution. They're going to be passive, though. They're not going to be managing the day-to-day operations. And so those members are going to be shielded from any sort of liability that might be created, for the most part, from the management of the company. Now, they don't forfeit all management rights. So let's say they have to remove the manager. They're going to have that ability through the agreements. Usually, you're usually going to have the ability to remove the manager at will, unless it's negotiated that that manager is not going to be removed at will, that sort of thing. But for tax purposes also, let's go back to financials. Generally, they're less expensive to operate. That's true. Whenever we're creating corporations, you're going to have designated shares. So we're going to authorize X amount of millions of shares, usually around 10 million of authorized shares, which are, a portion of which are going to be issued to the initial shareholders, as well as we might create an employee option pool. We'll get to that in a minute. But these are generally pretty straightforward because we're not sitting there going, we're authorizing X amount of units. We're usually sitting there going, this is just the percentage you're getting. Like that's all you get. For now, at least. And then, as far as tax structures, usually if you're a single member entity, you're referred to as a disregarded entity, which means that, the income, the profit, and any sort of tax liability passes through to you as if the entity did not exist, only for tax purposes though. So an LLC is technically a zone of protection around you as an individual. It's why we start businesses, to create that zone of protection. But as far as the pass-through structure, you're usually going to be taxed as what we call a partnership because in the IRS's eyes, an LLC is more of a legal fiction than anything. So it's not the exact same as a corporation as far as the IRS is concerned. That said, there are certain exceptions to pass through tax structures. So some of you might have heard of S Corp stuff. As far as making that election goes, S Corp elections are typically made when you have a certain level of income that you're earning and a certain level of profit to the point where you can pay yourself what we refer to as a reasonable salary. What does that mean? Well, the IRS never really tells us. But really in practice, what it means is you're probably going to be making in take-home pay from the business after you've paid all the business expenses, after everything else has been paid. You're saving cash for operating capital. Your take-home pay is something like 100,000 or more. So let's go ahead and it looks like we have a question that came in. Yeah. So the question is, whether it is a single member or a multi-member LLC, do you have to, or should you have some sort of compliance control organization involved? So, yeah. So here's the deal: if it's a single member LLC, a lot of times those will be running on your own for a little while, but you will have employees at some point, right? So whether you have one employee or a dozen employees or 50 employees, I mean, and whether you're a single member or multi-member and you have that many employees, yes, I mean, compliance control organization is pretty key. What we refer to that is, I mean, in some places, I mean, more academia, we refer to that as an accounting information system. I mean, we create compliance controls to prevent fraud. Because I mean, the moment you have one employee is the moment you have somebody who is creating some sort of risk that, I mean, they might commit some sort of misconduct in the name of the organization. They might act as if they are authorized when they are not. And so actually in those agreements, like, so for instance, a multi-member LLC operating agreement, especially the longer ones, we're actually going to list out, here is what you are authorized to do. And I'll give you a good example of that. So typically we put in a term that says you are only allowed to take out a loan or take out a line of credit on behalf of the company or run up a debt in the amount of no more than 10,000 or 25,000. Why do we do that? The reason is pretty obvious. Well, we don't want, I mean, the manager or anybody else who's in control of the company to be racking up massive amounts of debts without approval from the members or the other managers, right? So we want, we put that control in place so that in the event that happens, we have a way to say that is technically willful misconduct because you violated an operating agreement, which is technically a breach of contract. At which point you can remove the manager, or you can actually make that, I mean, in some cases, that person will be liable to you for having racked up that amount of debt personally, because they will have breached the agreement, and the amount that they are in breach, or the amount that the amount that they violated the agreement in, can in some cases be imputed to the manager as an individual. Now, some managers will demand indemnity, which is basically like, hey, it doesn't matter what I do wrong, you're still indemnifying me so long as it's not willful misconduct. Though, I mean, if they're willfully breaching an agreement, knowing that those terms exist, then I mean, there's your answer. So yes, compliance controls should exist no matter what kind of organization you are in. I mean, I tend to tell people good facts, good law, bad facts, bad law. What does that mean? Good facts, I mean, you're being honest, you're running your business the right way, you're not committing crimes, you're not doing anything else wrong. I mean, usually to the best of your ability or the best of your knowledge. The law will be on your side and protect you, as well as, as well as reinforce that shield that the LLC or the corporation creates around you. Bad facts, bad law. You do something wrong, somebody else does something wrong, the manager does something wrong, the directors, the officers do something wrong, something that is well outside the scope of what they're authorized to do, or in some case, a violation of law or a violation of an agreement, in which case, bad law. I mean, that law is not going to protect them. They could be personally liable, in some cases. So, yeah, I mean, the compliance measures are a good thing, not a bad thing, and you should embrace them from the very start. As a business practice. That's not even legal advice. That's literally just business advice. So yeah, the con though, to go through it, there's somewhat less protection for investors compared to corporations, for LLCs. Though I will tell you, if you're running a manager-managed structure and you are an investor who is a passive member of the business, generally speaking, you are not supposed to even be managing the company anyway. So the LLC still does a good job of protecting you. Other factors considered, right? So, no absolutes here, but LLCs are not taxed directly or taxed twice like other organizations are. Though, if you do have employees, you do have to pay withholding taxes. Some cases you have to pay workers' compensation taxes and things like that. That's what you set up with the state you're in. You pay taxes based on, you pay income taxes based on the state you're in, as well as federal income taxes too. I mean, I'll tell you the con that we often see from the managers and the members or the managing members is they're a bit less conscientious about management of their entity. It can often be the case that they either don't do the upkeep, like as far as paying state taxes or filing annual reports or things like that. They tend to think they don't need to do anything else other than get an LLC set up. That's simply not true. I mean, I'll tell you, I've talked to several accountants, and one accountant I've spoken with, I mean, has said the moment you reach about $50,000 in annual revenue that's recurring, you should probably look into having an accountant assist you with management of the financials and the bookkeeping and things like that. To give you an idea, we just did that. I took on an employee recently, and I mean, we got everything set up: payroll, withholding taxes, I mean, everything. And we're also, I mean, preparing for the next year financially because we're making a different tax election and stuff like that. And I'll tell you, like, I mean, as you grow, I mean, you'll get more conscientious. You'll start putting other professionals in your corner: accountants, wealth managers, if necessary, lawyers, what have you. So also, I mean, one of the other major cons: members more likely to use the entity improperly. We oftentimes see them commingle assets. I mean, we oftentimes see them attempt to charge against the accounts in a way that's improper, or at least, I mean, doesn't really make sense. I mean, to give you an idea, let's say you're billing tons and tons of, let's say you're billing tons and tons of like travel expenses, entertainment expenses to the business entity. In some cases, that might be luxurious. You probably don't want to be doing that too much, because it's, I mean, with certain expenses that are deductible against your taxes, I mean, you have to make sure you're abiding by the rules for those. I mean, for instance, I mean, if you're going to use your car for the business and you are going to take the tax deduction for that, you have to track the mileage of the car. I mean, what did the mileage start out at when you started using it for the business? What ended up happening when you started, and then, I mean, you have to track it each time. I mean, designate it personal or business use. They can get pretty complicated. And at that point, I usually tell people, like, hey, if that stuff is a concern to you, I mean, go talk to an accountant. Those people can definitely advise you of that sort of thing. Yeah, and I mean, here's a couple different things. So, like, a lot of times we see, some LLCs set up as holding companies, and that's pretty common. To give you an idea, we're setting up a holding company for a property management company that's managing about $100 million in assets at the moment. And the reason we're doing that is because that property management company has a property management entity. I mean, they also have a realty and brokerage group. They also have they've also got a roofing company. They've got a contracting company. And so we're basically going to establish a holding company, have all of those other entities roll up to the holding company, and establish an extra layer of protection for them. And that was actually something their accountant brought up that they wanted to do. They were like, hey, you're reaching that level where we think it's time. And in some cases, people don't want to do that because it's just another entity. I mean, it's an additional step, an additional filing each year, but it is what it is. We get asked to do that sometimes as people grow. So, and it's not a bad way, I mean, to warehouse certain assets like intellectual property. It's not a bad way to separate out certain assets. So if you own individual parcels of real estate or homes or commercial rental property, it sometimes does make sense to go ahead and do that. Do we have any questions about LLCs before I move on to corporations and talk about that at length? Okay, well, anyways, we're going to move on to corporations. So corporations are slightly different. The general thing you need to be aware of is corporations tend to have much more, tend to be run a little more seriously than LLCs. So you are going to have quarterly filings. I mean, you are going to have a large annual filing usually. You're not going to have such onerous filing requirements as publicly traded companies, unless you are a corporation that is a publicly traded company, which, by the way, In order to be a publicly traded company in the United States, you must be a corporation. I don't think I've really ever seen any other type of entity that was a publicly traded company in the U.S. But aside from that, you do get maximum protection from personal liability usually. I mean, so long as you're doing everything right. That's for the directors and the officers, as well as the shareholders. It's ideal if you're obtaining capital soon after starting up. So your startup company, you need to go out and get venture capital, no matter what it is. I mean, and I would recommend this even if you are doing a friends and family around, even if you're, even like whether you're skipping the friends and family around and just going on to pre-seed or seed. I mean, you probably do want, to start a corporation. It's also, I mean, as of right now, I mean, we don't know what will happen post-election. Especially if Joe Biden ends up winning, I mean, there is a chance that, I mean, the 21% tax rate for corporations will get rolled back and become higher at some point. But I mean, for now at least, it is actually, it's not as bad to start a corporation as it used to be. Previously, accountants would be like, I think back when President Obama was still in office, we had like a lot of the advice previously was like, you should definitely have an LLC instead of a corporation, at least at first, because it's going to be tax advantageous to you. As of right now, I mean, being a corporation is, almost as tax advantageous, if not almost more in some cases, than an LLC. Whether that's the case for you, I would highly recommend that you go talk to an accountant about that, because that's something that, we provide minimal tax advice, only enough to give you an idea of whether or not you should talk to an accountant as far as our dealings with our clients. So for venture capital, I mean, most investors, especially institutional investors, are going to want to see that you are a corporation. It gives them more protection as an investor. It also provides them with, I believe, better recourse. Against you as far as decision making. A lot of times we can structure in like fiduciary duties to the shareholders and things like that, so that in the event you violate any of your duties to the shareholders, and you start doing anything that's self-dealing or self-serving, they can potentially go after you for doing that. The other reason why we do this is, many investors, many institutional investors, just generally entrepreneurs are just more comfortable with it. Also, Delaware corporations, by the way, are quite literally the world standard for how to start a business that is raising money or running a tech startup venture that will eventually raise money or eventually go IPO. And so, if you're looking at, I am planning to IPO 5 years from now, because that's really the only way to get this thing truly into profit territory, or truly, massive scale. Then Delaware Corporation is probably going to be your best bet. I do want to say, and sometimes I'm saying things that sound pretty affirmative or definitive. Please keep in mind that, there are no absolutes here. We're doing stuff that, we have to assess it on a case by case basis, have to see how many people are involved, what rights those people want. What the terms of these agreements we're talking about are going to be, et cetera, et cetera. So, and I say, in some states, it's a greater shield of business assets, including distributions to shareholders and owners. In Delaware, that's pretty true. For Texas corporations, there's a little less protection, I believe, than Delaware. If you compare the law, the running joke about some Delaware corporation laws that the courts have generally said, we believe you can do no wrong. Basically telling them, so long as these agreements protected you, even if it seemed really bad, technically you probably had the right to do that anyway. That said, I mean, don't use that as a statement that would allow you to go commit willful misconduct or fraud on behalf of your company. I mean, to something most people should be aware of, if whether you are a single member entity or a multi-member entity, no matter whether you're a corporation or an LLC, committing fraud is still fraud and you will be personally liable for it. The one thing that setting up an entity does not protect you from is committing fraud, for sure. And so, like, as far as corporations go, very good for national, multinational companies. So, I mean, if you're going to have national reach, if you're going to be internet-based business and have national reach or even global reach at some point, probably a good idea. I mean, you can set it up as an LLC. But I would say a lot of people, especially if they want to acquire you in full, or at least acquire a majority stake in your company, or even a minority, they're going to want to see that you're a corporation. So cons, though, stricter corporate governance requirements. You're going to have bylaws. In some cases, you're going to have stockholders agreements which will look very much like operating agreements for LLCs and have very similar terms. You're going to have double taxation, which basically means, if you are an owner, so let's say you are a director, officer, and a shareholder of the company, then, the profits of the company themselves are going to be taxed. And then on top of that, if you make any distributions to yourself as dividends, those are going to be taxed as well. So some people view that as a negative. Some people just view it as the cost of doing business. LLCs, if you're partnership or disregarded, if you're taxed as a partnership or disregarded entity, you're usually not taxed twice. That said, there are exceptions to that rule. You could conceivably make an election to be a C corporation. You could be an LLC that is taxed as a C corporation, or an LLC that's taxed as an S corporation. Similarly, as a corporation, you could be taxed as a partnership, or you could be taxed as an S corporation. Whether that makes sense for you is up to you and your accountant and whatever research you do to figure out whether that's right or not. I'm not really advising on that on a whole lot on this webinar today. If you have any other questions about that, I can direct you to people, though, who might be able to tell you a little bit more about which election would make sense. As far as another major con, corporations are generally more expensive to start up. So, and in some cases, like, to give you an idea, the difference between startup cost that we charge to clients, is for an LLC, compared to an LLC, a corporation is going to cost you about 2.5 to 3 times as much. That said, you have to understand what you're getting. We're preparing these documents for you, and slating you for growth, in some cases, immediate growth. And so, for an LLC, if you're just planning on running a lawn care company or running a mom and pop shop business, an LLC is going to be more appropriate for you than a corporation, most likely. So, and then more extensive corporate governance documents. Some people, I'll tell you, probably one of the more frustrating things about what we do for businesses, sometimes people are frustrated with how long the documents are. Some of the feedback we get are, I hope you're not paying that person by the page. Okay, well, to your point, yes, we acknowledge that some of the agreements are long. Yes, they could be shorter, but you have to understand, when they are shorter, in some cases, we are removing a substantial amount of language, a substantial amount of protection for you as individuals, for you as shareholders, directors, officers, whatever it might be. And so, in some cases, longer is better. In some cases, longer is not better. In some cases, longer is just not appropriate. And in some cases, you need a shorter agreement because the deal needs to get done today, and you don't want that person looking at it and just saying, I'm not signing that because it's too long. So it is what it is. We do what the client wants as far as that is concerned, and we listen to them, and we will advise them, no, we believe a longer agreement is going to be more appropriate for this, and here's why. If they still say no, we'll usually tell them, yeah, we can do that, but you just need to be aware that there's risk there that would otherwise not be there if we had a longer agreement. So, Do we have any questions about corporations, like, at all? I went through that pretty quickly, but yeah. Yeah, that's actually true. So, I mean, your question is, I mean, could you basically operate a national company as an LLC? Yeah, that happens all the time. So you might see at the bottom of a web page a lot of times that you'll see that the business is operating as a limited liability company. Yeah, you can do that. I mean, when we're painting broad strokes with the statement about operating a corporation for nationally for a company with national reach, I mean, what we're saying is, I mean, yes, I mean, corporations are generally viewed as more protective for those purposes, but at the same time, an LLC is going to be recognized in every other jurisdiction in the country. And I mean, there are laws on the books which will generally recognize the LLC's law in that state, uh, like the law of the home state for that LLC in the other state. So let's say, I mean, you're operating a Texas LLC that has reach in Oklahoma. Something happens where you actually have to go present your case. What we basically do is we foreign register or make a special appearance in the Oklahoma court on your behalf and basically say, hey, I mean, we're appearing here. I mean, we may not be fully registered as far as like having an Oklahoma LLC, but I mean, we're afforded the same protection as we would be if, like, as a Texas entity. So, yeah, it happens both ways. I mean, and keep in mind, in some cases, what people are doing is they're operating an LLC because it is a lower cost of operation. It's more flexible, and I mean, it just gives them it, like, in their opinion, I mean, it's a less stringent way of operating the business, like, early on. But at some point, you might look at it and say, okay, well, these assets are actually now worth well over $1 million, not just on paper, but in terms of annual revenue. Okay, well, maybe it makes sense to convert into a corporation to further protect that income stream. You know, I mean, whether that makes sense is up to you. I mean, also, if you're looking at a potential sale of the company, I mean, it may make sense for you to say, okay, like, we're going to convert into a corporation. That way, I mean, the potential acquirer is going to be more comfortable that they're acquiring an organization that will protect them as well whenever they purchase it. So I mean, and there's a lot of factors that go into this. And but I'll tell you, I mean, it's fairly easy to convert an LLC into a corporation. It is not as easy to convert a corporation into an LLC. Doing the reverse, like, it is one of those things where, in some cases, we would probably just shut the corporation down and then start a new LLC and pass the corporation's intellectual property and other assets into that LLC. So. But you can run a national company for sure with an LLC. There's no big deal there. Like, when we're talking about this, like, it's more in the context of raising capital, further protecting yourself, et cetera, et cetera. So, aside from that, though, I mean, LLC organizational documents. Generally speaking, you're going to have in the state of Texas, you're going to have a certificate of formation. In other states, called articles of organization, called articles of incorporation, et cetera, et cetera. The company agreement or an operating agreement, which are the same thing. Restricted unit purchase agreements, IP assignment agreements, and then unanimous written consent for the initial startup of the company. So the thing I want to talk about, though, are restricted unit purchase agreements. So let's say, for instance, that you have a multi-member LLC. And, you're starting business with a best friend of yours, right? But you're unsure, really, if that best friend is going to stick around. I mean, yeah, I mean, that person is a hard worker, that person is a contributor, but at the same time, I mean, let's say, I mean, this is a regional business. That person has to move for whatever reason to a different state. What happens to them running the business? I mean, well, I mean, in that case, you could potentially protect yourself from that sort of thing where they would have to leave and no longer contribute to the business through a restricted unit purchase agreement or restricted membership interest purchase agreement. In other words, basically, you are keeping them on as a you are going to keep the person on under vesting provisions. So, I mean, they'll be granted a certain amount of the company at a certain point in time, and then the remainder of their stake will vest on basically on a monthly basis, a weekly basis, whatever frequency we decide, and like or a quarterly basis. And so long as they continue to serve the company in a way that's satisfactory to the company, if they end up abandoning their post, I mean, all you have to do is issue written notice to them. And then, I mean, you'll have, I mean, in some cases, the unilateral ability to basically repurchase the amount of the amount of stock that they have, the amount of stock or membership interest that they've given out, that you've given out. As far as those go, I mean, yes, some people look at those as hostile to certain co-founders, but at the same time, I tend to frame it a little bit differently. I tend to see it as you're sort of putting yourself at arm's length with your co-founder. You're saying, you know, it's not just you that has to contribute continuously for the next 2 to 4 years. It's me too. So if I leave, like as the CEO or something like that, I've got to get like I'm at risk of losing like that portion of the unvested equity that would have otherwise vested if I stayed on, as well as I'm potentially going to lose, I mean, the portion of equity that has vested because you can buy it back. And I mean, that goes on, like, especially for investors. Investors sometimes like to see that you have something along these lines. I mean, no matter what kind of entity, like for the corporation version of this is what's referred to as a restricted stock agreement or a restricted stock purchase agreement. And investors sometimes do like to see that you're brought in under those terms, only because in the event you leave, we can claw back the equity or at least cut you off and save the company from having to give you anything you wouldn't otherwise earn, right? So, I mean, those are a fairly useful way of structuring the equity portion of the company agreement, and I highly recommend doing that if you have multiple co-founders, especially if you have more than 2, because I can almost bet you money if you have multiple co-founders and it's more than 2 people, like you are going to have at least one person probably leave. Like, I mean, it is almost like a 9 out of 10 chance that somebody is going to leave. And if you did not have a restricted unit purchase agreement, like, or a restricted stock purchase agreement, and you couldn't otherwise cut the vesting of their membership interest or stock off, like you're going to be feeling that. So to give you an example, we had a company that recently started up to use LegalZoom. And I mean, their company agreement, their operating agreement was just woefully inadequate. And like, it was really more of a single member operating agreement when they needed a multi-member, and a very long one at that. They were each a third, and a third. Like, it was 3 co-founders. One of the co-founders ended up having to be fired because he was just not a good fit. And he just didn't work well with the other 2 co-founders. They ended up stripping him of any management rights, stripping him of his duties, which was allowed. But what wasn't allowed was for them to claw back their equity. And we had to go into negotiations with that person. We had to tell them, hey, go get a lawyer. We're going to draft up a membership interest purchase agreement, and we're going to buy it back from you. That dragged out for 2 months. I mean, what would have otherwise been something where we just notify the person that we're doing it turned into, like, this person was just so hostile, so combative the whole way through. I mean, did it to make it painful on purpose. And I mean, it was really one of those things where, you know, I mean, it would have been it would have been ideal if they had just had a lawyer drafted up instead of going through LegalZoom. And in some cases, like, I don't try to disparage LegalZoom, but their services are limited. I mean, in some cases to an extreme extent. And I think that's just being honest about their services, not necessarily bad mouthing them. But yeah, do we have any questions about LLC org docs at all right now? I'm about to do the mirror image of corporate organizational documents. So standard version of these is certificate of incorporation, bylaws, restricted stock purchase agreements, IP assignment agreements, and then unanimous written consent for the initial formation. The other agreements you might include, you might have a equity incentive plan that's approved already. If you're going to establish an option pool that you're going to award to third-party service providers. So think, I want to bring on an advisor or an outside board member. We're probably going to set up that option pool. We're going to award them a certain portion of the stock out of the option pool under agreement. We're going to tie them in under an advisory agreement, maybe coupled with a restricted stock purchase agreement, so that we have both an advisory agreement establishing that they're an independent contractor and they're just providing advice, no control, as well as vesting provisions. As far as other agreements go, you could have a stockholders agreement with this, which is, like I said previously, very similar to an operating agreement. You're probably going to have, the stockholders agreement, in some cases, will have terms like drag along rights, tag along rights, other very startup friendly terms, which would allow the business or the people who are in control of it, or the people who are majority shareholders of it, to drag other shareholders through sales. Basically allow them to tag along to sales if a certain portion of the company is being sold, things like that. These are generally the major 5 documents. Like a lot of people will say, set up the option pool, like initially whenever you're doing this. Like I said, no absolutes. I set up the option pool like at the beginning if that's what we need. The reason for that is, at some point, we may have an investor who's taking on such a massive amount that the option pool we've established technically it wouldn't be enough. And so if we just leave that amount of shares as unissued reserve, and then figure out, okay, this person is going to invest this much in exchange for X amount of the company, we've got enough left over out of the unissued reserve to be able to create the option pool in the amount that they want. And then we'll go and issue the option pool before they take the investment, and then boom, they'll make the investment and then obtain their shares, or make the investment and obtain a convertible note or a safe agreement or what have you. So do we have any questions about that or anything like that as far as corporate organizational documents go? Yeah, so you'll see in some cases that there is transfer on death language to the other members of the company. And in some cases, this will be structured. So like, let's say, really what we talk about is disability or lack of capacity or death. So those are the 3 major categories. So if you're disabled to the point where, you can no longer perform services to the company, that constitutes something where, some of the people in the company may be able to buy your shares back or buy your membership interest back. Lack of capacity. So let's say you're not necessarily disabled, but your capacity is hindered in a way in which you can't really perform work anymore. So let's say like something major happens, you have to leave the company, but you're not disabled like medically or anything like that. It's just like you lack the capacity now to be able to even continue to work. Yeah. So, that might constitute a situation in which we have your membership interest transferred to other people, especially if that lack of capacity is going to be for an extended period of time. Though I will tell you, a lot of times we see lack of capacity also equates to you lack capacity of the brain, lack capacity, cognitive function. The ability to do really anything on behalf of the company or hold a position of trust or management over the accounts or management over the customers, things like that. You lack capacity in the sense that, you no longer are fit to run the business. That is the most common example, but the other example I talked about is just as, is in some cases just as common. So an example of a lack of capacity could be, you get called up to do military duty. That said, I mean, there are certain laws related to whether or not you can and cannot do certain things if people get called up to do that. I wouldn't touch it really. I mean, usually in those cases, but um, in some cases you may toll the vesting provisions on some of the on that if you have like if a lack of capacity arose in a situation like that. But aside from that, the third option is, or the third common instance is death. As far as death goes, yes, I mean, that constitutes a change in control. The operating agreement should say something about that. If it doesn't, then it usually falls to the heirs of the of the potential member. So usually there's no common law or statutory right for the other members to be able to claw back the membership interest from the estate of the party who died. And while that might be seen as unfortunate, I mean, to give you an idea, usually the terms stipulate that if the membership interest is transferred in such a way that it's no longer owned by that member or owned by that original party, then, like, for instance, it's owned by the spouse of that party, then technically that does not equate to a change in control related to that membership interest. So under the law in the state of Texas, the rule is actually, I mean, if a member dies and there's nothing that speaks to it, I mean, aside from the fact that, well, if a member dies and the operating agreement says something to the extent of no assignment of control related to assignment of membership interest, I mean, regardless of how that's assigned, like then technically, like, that's just, it turns into what we would basically call non-voting membership interest. That person is treated as a member as far as the equity is concerned, but it's not like they would have control over the company unless the operating agreement speaks to that. The other thing to consider when it comes to people who are dying is or who may die in the future. And, like I mean, one of the, well, let me back up for 1 second. So transfer on death language, I mean, transfer due to lack of capacity should be common language in these agreements for anyone. It doesn't matter what age you are, but especially for older people, yes, we want that. But even for younger people, so even like myself, I mean, yeah, we look young, we look fit, but things happen. I mean, a tragedy could happen like tomorrow. And I mean, to give you an idea, like the way you should be viewing those terms is, the most dangerous thing we do on any given day is drive a car. And it actually is very dangerous activity. Like and people die every day driving cars. And so keeping that in mind, I mean, if you have transfer on death language, it's usually going to have something along the lines of, in the event of a transfer on death, there's going to be an appraisal process. Sometimes that is prescribed in the operating agreement. Sometimes it just falls to a third-party appraiser. Sometimes there's dispute resolution related to appraisal of the membership interest, at which point you're going to have a certain period of time to exercise the right to repurchase the membership interest upon death, I mean, or lack of capacity or whatever, or what have you. And then in some cases, I've seen people actually attach a promissory note that ties into that repurchase option, which is actually a good idea, I think. The promissory note, I mean, it effectively can create security for the person receiving for the person who is being bought out, or the estate of the person who is being bought out. And it can come with language that will say, you're going to pay X amount on a flat rate per month. And if you miss any amount of it, then, I mean, there's an interest rate that kicks in for the amount that you're in default, right? And so, I mean, there are certain terms and different ways in which you can do it, but that's generally the way I've seen it. But yeah, that's a very good question. It's pretty common that happens. But I'll tell you, I mean, sometimes I have actually seen in the past, like, some lawyers will intentionally leave it out, only because they don't practice wills, trusts, and estates law. They don't practice, I mean, the law related to the end of a person's life, and they don't go to probate court ever. And so they tend to stay hands off on that and just let the language of their will control, or the language of the trust or other testamentary instrument control that sort of thing. However you decide to do that, I mean, is up to you. Though I would say as a general practice, it's more often that we see transfer on death language in these agreements. So, good question. Do we have any other questions about that, or any other questions about org docs? Yeah. So this is a common question that comes up. So when should I convert an LLC into a corporation? We usually see this around the time when people are evaluating whether or not it would be tax advantageous to do so. There is a bit of calculus that goes into that, but we also see it around the time when people are going to start taking on venture capital money. So we recently completed a conversion from an LLC to a corporation. That business, it took a little longer than we would have hoped, but there were a lot of moving parts on it. But also, I mean, they were looking at, if this business is going to go on to be ultra successful, in ultra highly valued, more so than it is right now, which it was actually, the business we were talking about, was a $10 million business, on paper. The truth is they wanted to be a $100 million business though. And so, to get there, they would probably have to take venture capital to grow more quickly and give away a portion of the company. We advised them, at the amount that you're earning money, at the amount that, you're, and to give you that flexibility to be able to take on venture capital would make sense to be a Delaware corporation. And they went on to do that. Also, if you're preparing to IPO and you, for whatever reason, haven't taken venture capital money or private equity money, which would be astounding, unless you're a special purpose acquisition company, then at that point you're, if you're preparing to IPO, you have to be a corporation just to be able to even do an IPO. So yeah, it's also, we see it for riskier, higher value ventures, tax reasons, recent reduction in corporate tax rate. At some point, it might make more sense for you to be tested C Corp. Something to keep in mind as you grow. Do we have any questions on that? Yeah, so as far as this goes, so I style these in the way of like people asking me actual questions, like, I run a corporation, should I have subsidiary LLCs? It depends. Do you want things to be complicated or more complicated than they are right now? Maybe. If you have certain revenue streams, certain income streams, and it makes sense for you to complicate things further, then maybe. I will tell you in one case that probably does make sense. If you're entering into a true joint venture agreement, at that point, it probably does make sense for you to shield yourself a little bit further with an LLC that is a subsidiary that is wholly owned by your corporation. Now, I'm not going to get into the weeds, on whether or not, the liability passes through from the LLC onto the corporation and things like that. I'm just going to say, from a general standpoint, major, highly valued intellectual property. Sometimes we even see it with contracts. We'll create separate LLCs just to enter into those arrangements. A good instance in which we see, or a common instance in which we see a lot of people chaining LLCs to their businesses as subsidiaries that are wholly owned, is when venture capital firms or investors are investing in companies, and they're taking pretty big stakes in them. So oftentimes those people will set up an LLC, and it'll say, here's the name of my company, dash, here's the name of the investment that I've given it, probably the name of the company they're investing in, LLC. And they'll have a separate LLC for each investment that they do. And they'll terminate that LLC if one of two things happens: if they ever cash out, or if they ever, or if the stake goes to zero. So in some cases it makes sense. I've seen some people separate separate departments into LLCs. That's a little less common, though. I've seen it with publicly traded companies. To give you an idea, like AT&T has separate LLCs for certain divisions of their company, which, I mean, roll up to the parent entity. But I mean, we're talking like LLCs that run probably, I mean, several hundreds of millions of dollars worth of assets and revenue in any given year. And that's an example of how you could do that. I mean, but yeah, I mean, they could run a separate corporation that way if they wanted to, but it makes sense why you would just have a subsidiary LLCs too. Real estate assets is one of the more common ones too. If you own real estate, I mean, residential real estate especially, it's like the most common thing on the planet for you to have separate LLCs for each individual company, or for each, not company, each individual piece of real estate. So, I mean, you're running rental property A and rental property B are each going to have their own LLCs. And the reason for that is anything happens to the property, whether or not it was a defect of the land, defect of the way it was constructed. I mean, you become liable for anything like related to that. I mean, it would probably be better for you to actually have a separate LLC for that. That way, I mean, the value, like, I mean, that those people can go after, potential litigants can go after, is limited to the value of the property itself. And so, I mean, you get a judgment against that, and the court says, yeah, actually, I mean, you know, they're not going to be able to get to you personally. I mean, but they can attack the assets. At that point, you could liquidate, sell the asset, and pay off the judgment, and the rest of it could potentially be sorted out in bankruptcy. I'm not a bankruptcy attorney, by the way, so if that's something you need advice on, I can direct you to people who are. So yeah, and in some cases, people who have different operations in different states will have separate LLCs. To give you an idea, some companies, especially for employment reasons, will set up a separate LLC so that any employment issues arising out of that state are handled by that LLC alone, out of that LLC's assets. And if anything ever happened, they could probably just shut down that LLC and limit their exposure to liability to a certain extent. So aside from that, yeah, growing your business through individual contracts. So here, I mean, here's a common thing we run into. I'm thinking about starting a business and have an idea, but I don't yet need to start it until I'm sure. You know, sometimes we see founders agreements, which are on their face pretty simple agreements. I mean, they usually come pre-LLC or corporation. I mean, in some cases they come pre-name of those businesses. But it's really just like, hey, I'm in the process of deciding this. It'll have certain language related to, like, you know, this is non-binding. I'm not going to sit here and actually hold you to this agreement. It might have confidentiality, might have intellectual property, I mean, which belongs to one or both of you, or belongs to the venture itself constructively at the moment. But and so having a founder's agreement can actually be pretty useful, especially if you're exploring it right now but aren't fully committed. Founder's agreements aren't necessarily useful if you already have a company, because you already have founders or are the sole founder yourself if you already have one. So, and like I said, like, major disadvantage, why go to the trouble of this rather than just starting the business? The reason you would is because you're not sure about starting the business. But you want to explore it further and maybe seek out advice from people or see if somebody wants to partner with you on it. So that said, I mean, another way in which you can preserve rights related to an idea for a business that is not yet started is to just have a non-disclosure agreement. I mean, it's another way. And to that point, I'm thinking about starting a business and I have an idea, but I'm worried about talking about my idea. Maybe use a non-disclosure agreement, but there's a big asterisk on this. I mean, first step, quit worrying about talking about your idea. Here's the deal. A lot of people think their ideas are really, really special. Yes, you may have a very cool idea, but I will bet you money that somebody else has thought of it before. I mean, and that is one of those things that you probably need to keep in mind. I mean, be a little humble when it comes to your business, I have very rarely ran into someone who could actually, I mean, really command a non-disclosure agreement from potential investors. Only because, well, I mean, a lot of people will sign them, but like, I mean, we're talking about like the most recent instance was, we have a client that is papering up investors or potential investors with NDAs because the way they are monetizing their app is something that hasn't really been thought of before. To be honest with you, they haven't even told me how they're doing it. I mean, it's that secret. And so if it's going to be that secret, then, I mean, you probably need a non-disclosure agreement for it. But you have to keep in mind that some investors don't want to sign one. I'm particular, like lawyers, for instance, don't necessarily need to sign one if you're clients of ours, because we already have a duty of confidentiality. Though, I mean, I'm like, usually if somebody sends me one, I'm happy to do so. It doesn't really matter. I mean, because I'm already bound by that stuff. Actually, I'm held to a higher standard than what is in most confidentiality agreements. You can ensure confidentiality for a certain period of time. I mean, and recourse if someone steals or shares your idea and causes you financial harm. I mean, but you have to keep in mind, what will it look like to enforce it? So, and this is what I don't think a lot of people keep it like visualize, like, or understand from a practical standpoint. Like, let's say you have somebody sign an NDA, they go steal your idea, or you think they stole it, or talk to somebody about it. So you are going to allege breach of contract against that person. Or you're going to send them a cease and desist letter, or both, saying, hey, stop doing that. Or, hey, we've been damaged. I mean, in this amount, at least. I mean, we're going to demand payment from you. We're going to sue you. Well, so, I mean, like, the first and foremost, you're basically going to have to destroy your entire relationship with that person. I mean, you're no longer going to be friends with that person or even acquaintances with that person. You're going to be on opposite sides. Like, now, if you go try to enforce that. I mean, and usually people are going to throw up their defenses, throw up their, I mean, like, and it's pretty difficult to prove that sort of thing because a lot of people are just talking to people about it. Unless you have somebody who's willing to testify that, yeah, that guy shared all that stuff, or was willing to, like, at least go on record by signing an affidavit going, yeah, that guy totally violated and talked to us about that. Then, I mean, it's going to be pretty difficult for you to enforce it. But I mean, to give you an idea, non-solicitation and non-compete agreements are way more enforceable, only because it's pretty easy to prove if you are competing. As like, and it's, well, I wouldn't say easy. I would say it is way more feasible for us to prove it, because they're like, we can probably go to wherever they're working if they have a physical location, see who's working for them, and if those people are former employees of yours, if they sign a non-solicitation agreement, like, yeah, I mean, but yeah, it's a non-starter for many venture capital people. I think biotech is one of the exceptions. There might be a few other exceptions, but I generally advise people don't bother with a confidentiality agreement. I mean, the venture capital investors are looking at probably 10 to 12 deals a day, if not more. I mean, and so especially if they do high volume, like an investment practice. And so I mean, keep in mind that they're not sitting there signing NDAs for everyone. I mean, and if you truly cared about it, I mean, at the bottom of your slide deck, you just put confidential on it. Should be good enough. You go, I want to protect my company from lawsuits and avoid putting the company's problems on public display. Maybe use an arbitration agreement. Arbitration can be confidential, and usually an arbitrator is given the same discretion as well as the same ability to declare something as final as a judge is. We don't necessarily do litigation, which is like, arbitration is under the litigation umbrella, but we sometimes put together arbitration agreements for people. And the reason we want you, like, if you are afraid of being sued frequently, it might make sense for you to do that. I mean, that said, I mean, the better way to go about it is like, I mean, I've heard varying opinions. Like, well, not the better way to go about it. I've heard varying opinions from litigators who will say, I don't think arbitrators are that smart. I don't think they're usually that qualified, et cetera, et cetera. I have no opinion really one way or the other on that. It's more a matter of, I mean, do you want the ability to arbitrate? I mean, you can make it so that you have the ability to do that. I mean, and that the fallback would be just a bench trial or a jury trial. I mean, but I mean, you could say that, I mean, in the event that you choose to do so and you notify this person within a certain period of time, arbitration it is. And that's what we do sometimes. It can be mandatory, ensures that judgments are secret if you have like confidentiality provisions related to it. And then you can bind employees to this sort of thing. The exception to that is you may have heard in California that that's not so much the case anymore. That is true. California has become extremely hostile to mandatory arbitration provisions. We are not licensed in California, full disclosure, but I can read the case law and read the news. And from what I can tell, the Ninth Circuit, as well as practically everybody else, every other state court has become openly hostile to arbitration agreements that are mandatory for employees, especially lower level employees. The reason being is they're tired of people getting, I mean, they're tired of the judgments being secret. I mean, there's a very big public policy argument against it, only because, hey, I mean, these major corporations are just abusing the system in order to take advantage of their employees, who they rely on for all of their money. True. I mean, that's true. I mean, and that's a valid argument, I would say, against these sorts of things. I don't see this going super national, like in the short term, but we may see that spread from the Pacific in the Pacific Northwest to the Midwest and the East Coast fairly soon. I mean, the other thing to keep in mind is, like, with arbitration, in many cases, I think after the Harvey Weinstein scandal went fully public, and it started becoming more commonly known that cases of sexual harassment and even sexual assault were being mandatorily arbitrated. That was the point in which the courts were like, that's fairly extreme. Those are fairly extreme instances in which we do not want those to be arbitrated. We would rather those be hashed out in court, where, I mean, the forum is more public and, I mean, the records are more public. And so I think that actually does make a lot of sense. And I mean, to be honest with you, if that happened in Texas, I mean, I would say not a big deal, really. I mean, because to be honest with you, if you're afraid of hashing that out in public, I mean, then you might be guilty of something. I mean, aside from that, I mean, it can be prohibitively expensive compared to courtroom litigation, especially if the clause mandates more than one arbitrator. I mean, to keep in mind, I mean, these people are going to be paid like pretty well paid attorneys. And in some cases, they are not going to be attorneys. The blowback in the press lately, like I talked about, California. Another type of agreement, I need to bring on a real CFO, CTO, CIO, or other professional executive to grow my startup. You can use an executive employment agreement. Another way we do this for smaller early stage startups is just to bring them on through a restricted stock purchase agreement, and then maybe have a resolution detailing what the scope of their duties are and what they're limited in doing. So in some cases, we might explicitly say the CEO is the only person allowed to manage the bank accounts, or the CEO and the CFO are only allowed to manage the bank accounts, and the CTO is allowed to do whatever the CTO is allowed to do based on what we say. So usually, like, we are going to try to get that person in, though, like, especially if you are later stage. So let's say you've raised a Series A or a Series B. Like, at Series A, I mean, you're probably going to be bringing that person in under a mix of cash compensation as well as equity compensation. And so, I mean, we're typically going to be bringing those people on for a 2 to 3 year period, maybe 4 years, but I think 4 would be a little bit long. I see 2 years mandatory usually, and then I sometimes see 3 years, but we still do lock in vesting provisions on those. Make sure that those people are have to be service providers and show up. And usually, like those are these are not hostile things that we're negotiating with these people. Usually the CEO of the company is coming to us and saying, "Hey, I'm building this team, man. Like we really need this person. Can you cut this deal for us?" And so we go down and sit down, and both sides are trying to be as reasonable as possible whenever we're negotiating these. And so, but it is common for us to get company favorable terms like non-competes, non-solicitations. We certainly don't want a C-level executive coming in, understanding everything about a potentially billion-dollar business, and then leaving and competing directly with that business right after. We usually have to secure that with a 12 to 24 month non-compete. Sometimes the non-competes last a little bit longer. We can maybe get 3 years. Once you go above 3 years, you're kind of pushing it. Though, I mean, I'll tell you, I mean, if you're looking at publicly traded companies, a non-compete agreement could be as much as 4 to 5 years. And usually it's gonna be way more complex than the stuff that we're giving early stage companies, or maybe even later stage companies, only because like I mean, in some cases, these are just clauses rather than full-blown non-compete agreements. But we can do it both ways usually. So, but yeah, set salary, benefits, other compensation structures. I mean, maybe even put milestones in there for what they have to achieve, et cetera, et cetera. Do we have any questions so far? I've been going for a while and just want to give a chance if anybody has one. All right. Well, we'll go ahead. As far as so this is a common one as you continue to grow. Well, actually, it's probably not as common anymore because of the pandemic. But I mean, let's say, I mean, you need physical real estate to operate your business. Warehouse space. I mean, you operate a restaurant, you're going to need restaurant space. You operate a retail shop, you're going to need retail space. I mean, you operate a law firm like us at some point. I mean, you're going to need a law office at some point, like a physical space to take clients. If you're leasing or purchasing real estate for your business, I recommend you get a commercial real estate agreement or you get a purchase sale agreement in order. These are the types of things that I do not recommend you negotiate on your own unless you have experience doing that yourself. The reality is it is very easy for you to get taken advantage of when it comes to commercial real estate. Commercial real estate is very expensive. The language of the agreements is extremely complex, at least for a layperson who hasn't studied it or done one of these deals before. And I mean, and oftentimes, I mean, you're sitting there wondering, what the heck is the market rate for this place? Can we even negotiate the price? I mean, and usually I would say, yeah, you can negotiate the monthly rate for that real estate. And you should. I mean, keep in mind, like they're telling you that, I mean, this triple net lease is $10,000 net a month. Okay. Why? Like I get the taxes because I can actually see how much you're paying in taxes on the appraisal district website. But I mean, what I can't really see is the lease agreements that you have with everybody else in the strip mall or stuff like that. And so, I mean, that's not to say that you can go ask the owners of those businesses because usually these agreements have confidentiality provisions. But at the same time, I mean, you probably want to look at what's market for this. So go online, do some research, figure out in the general area, what is some similar size space? What is some similar size, I mean, locations that are operating retail or the same exact type of space that you need? And what are they going for? And I mean, and you should really, I mean, take a slow and steady approach to getting commercial real estate. A lot of people, they fall in love with a place and they pay way too much and they get underwater on these things very quickly. And so, I mean, I don't recommend you enter into these unless you have the capital on hand to be able to pay them for months at a time. And that's what happened to a lot of people that ended up going bankrupt recently or going out of business. It wasn't the fact that their business was truly destroyed, though that had a lot to do with it. It had to do with the fact that the rent was too high. and there was absolutely nothing to control for them for money that was going out the door. I mean, for rent. I mean, it was just, I mean, and to be honest with you, rent was pretty high to begin with in most of the country. It's even higher now for residential real estate, though I believe it's going lower for commercial. But yeah, like I said, somewhat treacherous without counsel. You can do flat monthly rent or triple net. Triple net usually includes taxes that you'll be liable for, things like that. Make sure you get parking. Gosh, oh my gosh. So like you've probably gone to places where there's no assigned parking for an individual space, right? Let's say that there's a major anchor tenant. So you got a big coffee shop in this strip. I mean, and the coffee shop like has people that are staying there literally all day, taking up all the parking. There's no time limit on the parking lot. You go in and buy your retail space or your restaurant space, like down the strip. But the problem is you didn't buy parking. So your customers now have nowhere to park. I would tell you that, I mean, you really do, like if it's going to be essential for you to run your business and you can see based on the way the parking lot is laid out and you can go there during prime time, go there during rush hour, go there during whenever it gets super, super busy for that location, and you can see how busy it gets to the point where there's no parking, you probably want to have a couple designated spaces, if not just one. That way you have somewhere for your customers to park. It's often overlooked, but it's a pretty essential aspect of those agreements. There's usually a due diligence checklist we go through for these things. I mean, in some cases, the lawyers will even do a physical walkthrough to make sure that, everything looks legit, which actually is pretty helpful from a negotiation standpoint, because I can negotiate stuff and quarterback it virtually for you. But going and seeing something with my eyes, I can sit there and say, this is busted, this is broken, this isn't working well, this is going to break. I can tell that. Like, we can sit there and negotiate the rent lower for you because, well, hey, I mean, quality is quality, and that's what you're paying for, right? Other things, zoning permits, license. If you need to get zoning permits or licenses, I mean, if it needs to be rezoned for a certain purpose or needs approvals, you probably want a lawyer to help out with that as well. Do we have any questions about this? I mean, this is actually one of those things where a lot of people have questions, and it's just it's one of those things where I highly suggest, major point that you take away from this is hire a lawyer to do commercial lease agreements or commercial purchase agreements. You'll thank yourself later. So I need to hire a programmer to build my company's software app. Definitely use a software development service agreement. We do software development agreements all the time. Those are super helpful. As a matter of fact, like there are certain issues that go into those that you absolutely need to be aware of. I mean, take for instance, like, so you have, let's say you find a software developer who has developed this really niche background technology. So, I mean, but you need to plug that into your current technology or the technology that you're developing. You want a software development agreement that's going to have background technology license language. You want that stuff to be perpetual. You want it to be irrevocable. You want to make sure that you're getting work for hire language, that you're getting ownership of the IP that is being developed on your behalf, and that, I mean, the IP is going to be transferred, whether it's complete or incomplete. I mean, so long as you have paid, right? As well as, like, there's various issues. So sometimes what we do is we put out a milestone structure, and I mean, in some cases we'll make it as specific as you'll get paid X for this, X for this, X for this, X for this, X upon delivery. Like, we try. I mean, milestones can be good and can be bad. I mean, sometimes it's easier to just pay somebody by the hour, and it can go pretty quickly that way, rather than doing milestones. Milestones can be paid up front or can be paid on the back end whenever the milestone is completed. And then, I mean, like, I'll tell you, like, as far as the milestones go, those need to be fleshed out. I mean, you definitely they need to be general enough to give you the flexibility to determine stuff while you're working with your software developer. but they need to be fleshed out to where the scope of work is actually defined enough for the software developer to know what he's doing. And usually I tell the software developer, create the milestones like for this, if that's the way they want to work, because I mean, they speak that language. I mean, they know the terms. And so I have them scope it out, and then we put our legal touch on it, and then we usually finalize it. So, and that's a pretty easy way of doing those things. But this is something that comes up pretty often. You definitely don't want to have somebody develop software for you without some sort of agreement that that person is a third-party contractor who is going to owe you the intellectual property as a result of their work and the fact that you're paying for it. I would say that's important. So we don't really have that much more time, but I'll talk about this briefly. As far as employees and independent contractors go, the IRS has like a 20 to 25 step analysis. I think it's like 25 or something like that. It's a long list of factors that are used in order to determine whether somebody is an employee or an independent contractor. And it's a balancing test. So we're sitting here going, more in favor of you being an independent contractor, or, more in favor of you being an employee. And the ultimate definition, the way I sort of frame this for people so that they can understand whether somebody is an employee or an independent contractor is, are you paying this person and you are not worried about the methods used, the means used, or anything like that, and you are only worried about final results, like whether they did that job whether they did the job properly and delivered something that was satisfactory to you, like they delivered results? Or are they doing something where you are controlling every aspect of what they do, giving them clearance and authorization to do that? I mean, and then directing them when to show up, what time, what to use, what to do. And so like, if you're exerting a level of control that is, pretty granular to the point where we can sit here and say, yeah, you're controlling this person's every activity, and they would be fired if they did it wrong, or at least disciplined if they did it wrong. Then yeah, that person's an employee, probably. A lot of people though will try to say, no, these people are independent contractors, man. Like, especially for early stage startups, they're like, I don't want to pay withholding taxes. Okay, but keep in mind, well, I won't say okay, I'll say, here's what you should keep in mind. It is not that you can't get away with it, because a lot of people do. It is that at some point, you might not always get away with it. And it usually comes about when somebody goes to some place like the Texas Workforce Commission and complains about the fact that they are treated like an employee despite the fact that they're called an independent contractor. And then what the TWC does is they come to you and say, hey, we want to know everyone who's employed by you. And we also want to know what you think of the level of control, because it sounds like you're employing people and not paying withholding taxes on their behalf, and not paying workers' compensation fees to the state. And so if that happens, the TWC has an appeals process. They'll mail you a letter. Et cetera, et cetera. And if that happens, you should probably talk to an attorney, or at least try not to fight it on your own. If you can avoid it, because if you don't have an attorney covering you on that, it's very easy to slip up in a way in which you're going to disclose something or just provide information to the TWC where they'll just go, yeah, you're an employee. There was actually an instance, I think, years and years back, where the TWC sent letters to people. It was almost like a sting operation where, they were just sending letters at random to companies and basically telling them, hey, fill this out, send it back. And apparently it wasn't even mandatory that they do that, but it looked like it was. And apparently it was enforceable. Like the representations that were made about that stuff was enforceable. And a lot of people who had independent contractors who were classifying their workers as 1099 ended up having to pay a lot in back taxes, because the TWC made determinations that they were misclassifying people. And that's the ultimate threat here. I would recommend you not misclassify your employees for whatever reason. I mean, don't misclassify yourself either. You always want to make sure that all the workers for your companies, including you as a person who's running it, are classified properly. So aside from that, I don't really have much more time to go through this because we're out. If you have any other questions, please feel free to email me at kyle@joneskertz.com. I would love to speak with you, would love to talk to you, figure out what you're doing. But aside from that, wish you all the best of luck with whatever you're working on at the moment. And we'll see you next month on Tuesday, on the first Tuesday of November, which is Election Day. And we're going to do an Election Day special. All right. Take care, guys. I'll talk to you later.